Houston Real Estate Radio starts right now.
Okay, we're back with Brian Cweren from ApartmentLawyer.com here on Houston Real Estate Radio. We're talking about tenant and landlord issues. And Brian, I wanted to know, when we talked about in the last segment how long it takes, or the process of evicting someone, but how long does that take from, beginning to end? And what's the shortest you've seen and what's the longest you've seen?
Well, I tell you, it's not an overnight process. So anyone who thinks that they're going to have someone who was refusing to leave their property out in a few days or a week, you have another thing coming. But it's certainly not going to take like other states or other countries where it may take years. It's not that bad. So in Texas, I would say we'll do a rough outline. In Texas, a minimum, unless the lease says otherwise, the default is a 3-day notice to vacate. 10 days if you're seeking attorney's fees and the attorney's fees are not mentioned in the lease. So 3 days for that. Then I would recommend to my clients you wait till day 5 or 6, depending on how you serve that, before you actually go file at the courthouse. And that in itself, once you file it with one of our JP judges, you should anticipate it taking at least 7 to 10 days before they get the tenant served. And in some case, 2 weeks is 2 weeks. But keep in mind that this varies depending on the time of the year. Certainly around the holiday time, it is drawn out a lot more. After all, judges are elected officials. They're not too inclined to have court appearances necessarily to put people out around Christmas time. Yeah. It always makes for a good news story. So you want to tread carefully and understand that around the holiday season. And in December, you're going to take more time. So once you appear in court, roughly I would say you will be in front of that JP judge on average approximately 2 weeks after you have filed your paperwork at the judge's counter. Then you appear in front of the judge. The tenant has 5 days to appeal. And otherwise, after that, you can then purchase the writ of possession, and the constable will come out because you have purchased that writ. Here in Harris County, that fee is $130. So the constable will come out and contact you. You will hear from that constable, and they'll come contact you, I would say on average, in about 2 weeks. So they're not going to come out overnight. If the tenant appeals from the day you're in front of that JP judge to get in front of the second judge, the county court judge, you are looking at easily at least a month. That's the short side of it. More likely 2 to 3 months, depending on how quick the county courts can get you in there. Texas law tells the judges to get the landlords in and out as quick as possible, and they are actually given an expedited track. So when you appear in front of a county court judge who have very heavy dockets, they have cases that may have been around for 6 months or a year, and yours has only been around for about a month or two. You're gonna be in there quicker than a lot of other people just to get the landlords in and out and the resolution of the possession matter resolved quickly. So it is easily something that could take a couple months if it's appealed by the tenant. And I've even had tenants that have taken it up even the next level to the Court of Appeals, but that's a rare scenario. Wow. And they certainly have to post if you ask for it, they've got to post a large cash bond to remain on the property to take it up with the Court of Appeals, who could take perhaps 6 months to a year to make a decision. But that part of it is extremely rare, and it only happens in a handful of cases.
Now, are any of the costs of eviction, is that something you can take out of the security deposit, or is that something it's an out-of-pocket cost of doing business as a landlord?
Yeah, certainly you can deduct that from your security deposit. And I would also remind people who are listening, that are landlords, that you want to make sure you get that security deposit accounting back to a tenant within 30 days of them moving out of the property, because the law does provide, the property code under section 92 provides for penalties for landlords who failed to get that accounting. And the slang term in the industry is the SOTA, security deposit accounting, back to the tenant within 30 days of them getting out. But that's your opportunity to make deductions for the late rent, for damage to the property, for filing fees, legal fees, stuff like that you want to mention in there. But you certainly want to get it out. I tell my clients to send it certified so you have proof. The downside, if you fail to meet that timeline, could be treble damages against the landlord, a $500 penalty, and attorney's fees, So you want to be careful in making sure you get that out on time as well.
So if with the security deposit, if they do damage to the property that exceeds the amount of the security deposit, what do you do then? Can you take them to small claims court? How do you recover those losses?
Absolutely. And I get that question a lot from my clients, especially the smaller operators of what do we do? The larger management companies operators turn them over to collections for the most part and attempt to get the tenant to pay that deficiency on their deposit. I tell my clients, you've got to think about this, first of all, because depending on how much is owed, and certainly you want to send them out their statement and tell them what the balance is owed, but do you take the next step of filing a small claims action, which is one possibility. Another is to turn them over to a collections agency and to see if that proves anything. But to turn them over to go to small claims court. And I remind my clients, when you do that, there's always the possibility that they're going to file a counterclaim against you. Mm-hmm. And you have to sit there and think to yourself, well, are they going to have any arguments against me? Was I too late on getting something repaired that was rather serious? So you want to factor all those things in mind, the time involved. But you can open up a Pandora's box by filing that suit and then bringing the counterclaim. But if enough money is involved and you certainly have held up your end of the deal of being a good landlord and you've made everything repaired and there have been no issues like that, that is certainly your right to get them served. Also, you may have the problem of how do you find them. So sometimes I advise my clients, if you think you're owed enough money, you may want to file your small claims case pretty darn quickly before the constable puts them out to get them served, because you have an address of where to serve them. That's your house. But once they're out of there, then it's a difficult time even finding to where to go get them served, right, to even get them into the arena. And then another important question is, does the tenant have any assets? You're going to go pay a filing fee. You're going to pay a constable to go serve them, or a private process server, and you're going to have your time of going in front of the judge. What assets does the tenant have that you can go after to collect on that?
Mm-hmm. Yeah, it's important to look at that. You have to weigh it, to see if it's worth it. You talked about the whole eviction process. At what point how do you actually get their furniture and stuff out of your house?
Absolutely, good question. The landlord should never be doing any of that unless they're instructed to do so by a constable. So in Texas, we delegate the enforcement of the judge's order to our constables. And when you go to eviction court and it's over with, it hasn't appealed, you purchase the writ of possession, and the constable contacts you and they come out and meet you at the property. The constable, depending on which one it is, may come with a moving company who will load up stuff and take it away, where it is charged to the tenant to get it back. Or you may have constables who may choose to put the stuff on the sidewalk. Or you may have constables who will turn to you, the landlord, and say, okay, it's yours. You're hereby told to get rid of it however you want, and you have to have staffing to get that stuff out. You're going to want to have a locksmith to quickly change the keys, but not until the constable tells you. And the really fun part is where there are special circumstances and issues involved to where you may not even want that stuff. I've had clients who've had bed bug issues, and you certainly don't want to be going in there, and that becomes complicated, and you have to bring in specialists to remove the stuff. And guess what? The constable doesn't want to touch it either.
Can't really blame them, right?
Now, what about midnight movers? People that move out in the middle of the month, in the middle of the night, they know they don't have their rent, and they duck out in the middle of the night. They leave stuff behind. When can you go in and take possession of it, or can you take possession? And is that your property to dispose of at that point?
That is a very good question. My thought on that is, first of all, the midnight mover may in some part have done you a favor, saving you through the eviction process. If they take everything with them, the problem comes up, they leave some stuff behind. I tell my clients that if they've left any of their personal property, they're still in possession, and you want to go through the eviction process, even if 80% of their stuff is gone, 95% of their stuff is gone, and only 5% is there. I strongly recommend to my client to go through the eviction process, and here's why. In my line of business, I will, out of every so many of these incidents, will see where a lawsuit comes in and the tenant says, you know what, I wasn't done. I wasn't finished moving my stuff out. I was trying to borrow someone's pickup, and I wasn't completed, and you've interfered with my right to possession.
And even if it looks like it's all trash, you'd still go
You
through
can't
the eviction.
toss it.
Yeah. I wouldn't toss it. What's that saying about someone else's
trash is another man's treasure.
I wouldn't do it. And always take pictures, and just protect yourself from giving the tenant who couldn't afford to pay rent the opportunity to come back and say that you took this huge financial empire they had, 20, 30, and I've seen those lawsuits, $40,000 worth of contents that you, the landlord, took, even though these are the same people who couldn't come up with the $300 or $400 a month rent to pay you.
Yeah.
And what about when they move? If they do take all their stuff with them and they move and they just owe you rent for past due rent, you just go to small claims court?
Yeah, small claims court, or some people are with credit agencies where you turn them in for collections and go out at that route. But small claims court, but you have to know where they went to, and sometimes
Got to be able to find them.
Yeah, sometimes you can. Sometimes you certainly can do that. One of the best tricks I give to my clients is to send your house where they were renting from you, send them a certified letter, and eventually that certified letter will come back unclaimed because they know it's coming from you. And many times the post office will put that new forwarding address where they live at on that return envelope and will help you track them down where they live.
Very good. A lot of good information.
Brian, fascinating interview. Really, really good.
Thank you for having me.
Yes. Please come back sometime.
We appreciate it.
You're listening to Houston Real Estate Radio. We'll be right back after a commercial break.